Good evening and welcome to the October 2016 Richardson Law Office's Legal Hangout. I'm Steve Richardson, and this month we're going to talk about bankruptcy issues and divorce. There are a lot of issues that can come up in a bankruptcy when one or both of the parties in the bankruptcy are getting divorced. So I wanted to talk about that here this evening because there are a lot of issues that you need to be aware of, not only legal issues but timing issues and things like that, and using bankruptcy as part of your overall divorce strategy. Just a few things to point out for this hangout. Number one, we're dealing with New Jersey divorce law. I practice here in Southern New Jersey, so I really am talking specifically about New Jersey law. So just bear that in mind. Secondly, this doesn't, don't go out and after you listen to this, go out and make some decisions about bankruptcy. This really doesn't replace a consultation with a divorce and bankruptcy attorney on these issues, because although there are a lot of general principles, your mileage may vary, your case may be different, and you need to get a proper analysis of it. So the third thing is, this is really, again, for informational purposes only, to help you decide on some of these strategies, maybe identify a few issues to talk to your divorce attorney or a bankruptcy attorney to see how these issues may affect your case. Now, I guess that the first question that people would have is, how would bankruptcy help me in my divorce? Why should it be in my divorce strategy at all, in my divorce toolkit? First of all, a lot of divorces come about due to financial stress. A lot of marital debt weighs them down, creates a lot of arguments and stress in the marriage, which ultimately causes it to break down. I have an attorney friend of mine who practices bankruptcy and says, one divorce is good for two bankruptcies. Kind of cynical, but it points out the very real aspect of divorce that can lead to bankruptcy and make bankruptcy oftentimes a good idea as part of your overall strategy. Now, in a divorce, you may be dealing with marital debt. Who has to pay it? Who's responsible for it? That can be a big issue. What do you do with the marital debt? Well, in a lot of cases, just filing a bankruptcy, a Chapter 7 bankruptcy to get rid of the debt, that takes that issue off the table. It takes that complication away from your divorce. You no longer have to deal with that. So that's important. And can be very helpful. So you want to look at the marital debt, who has the marital debt, and to what extent just wiping it out, getting that fresh start, and removing that issue from the negotiation table in your divorce. Also, if there are support issues, for example, if one party is going to be paying a fair amount of alimony and or child support, but has a lot of credit card debt, for example, getting rid of that credit card debt and that financial responsibility will free up income to make it easier to put first things first and provide spousal support through alimony or child support. So bankruptcy can be very helpful in that regard. Now the question also becomes, do both of you have to file? In general, what I tell people is just because you're married doesn't mean you both have to file bankruptcy. I do look to see who has the debt and whose name it is, to see, can we save the credit of one of the two people, and then just have the other person file. So there's nothing that says that just because you're married, you have to file bankruptcy together. Depends on where the debt is. I recommend a joint bankruptcy where a significant amount of the debt is joint, or maybe instead of having joint credit cards, each of you has your own credit cards, your own debt. It's been kept very separate. A lot of couples in the course of a marriage tend to do that. The financial philosophy is instead of a joint checking account, they all have separate accounts. You pay the mortgage, I'll take care of the food and utilities, and everything is kept separate. So if your separate debt for both of you is significant, it may not be joint, but you both have heavy debt, then that would be a reason to file jointly. And also if there is significant medical debt. Under New Jersey law, let's say the wife has a lot of, had a lot of expenses as a result of a pregnancy. A lot of medical expenses that remain unpaid. The husband, the spouse, can still be held responsible for it. It goes back to the 1940s, 1950s, where the old days where the man was the breadwinner and the woman stayed at home, and the wife was rendered medical debt and rendered medical services and incurred medical debt. And the husband couldn't just say, "Well, hey, I didn't get the services, my wife did. I don't have to pay for it, and she doesn't have any income." So the courts looked at this as a duty to support. Say, hey, look, you're the breadwinner. You bring home the bacon. You pay the bills. Your wife does not. So you're responsible for those medical bills. And of course, as times changed and women started going into the workforce, and you have dual income families, or maybe you have a house husband or a stay-at-home dad, and the flip side came in as well. So there's a general duty of support of spouses to each other, where that you really have to consider the medical debt as being joint. So that would be a reason to have both spouses file the bankruptcy. Now, next question is, do you each need your own attorney? Well, that again is on a case-by-case basis. It may be possible, depending upon the issues involved in your divorce, for one attorney to represent both of you in a joint bankruptcy. But that really is case by case. You need to talk to an attorney, talk to your divorce attorneys and see what the issues are. Talk to the bankruptcy attorney to see if this is something that be handled by one attorney, or whether you have to get separate attorneys and essentially file separate bankruptcies. So unfortunately, there's no clear answer because every case is different. The only thing I can tell you is not necessarily. So you need to look into that. Now, next question becomes, when do you file it? Do you file it before the divorce is final, or do you file it after the divorce is final? Well, I would say that in most cases, with some exceptions, obviously, most cases, it's better to file it before the divorce is final. Again, takes the marital debt issue off the table, simplifies the divorce in a lot of cases, and it's easier, and it has some other benefits. For example, before the divorce, unless one spouse has already moved out, if you're still living together but getting divorced, then that home is still considered to be your residence, and there are more exemptions in a New Jersey bankruptcy that could protect the equity in that home. So it's more likely, if there is equity in the home that needs to be protected, and you don't want that going to creditors, then having both of you living in the house as the residents, using the residence exemption to protect that equity. Second of all, it's cheaper. If you're both going to file, it's cheaper to do it before the divorce than afterwards, because married couples can get a twofer. They can file once for a joint bankruptcy, and really they're the only ones that can do that. You can't, siblings or things like that, they can't file a joint bankruptcy. It's only a married couple, so there's an economic aspect of it too. It's less expensive if you do it before the divorce is over, and it also gets things over with faster. I mean, Again, it simplifies issues. It doesn't take that. I mean, Chapter 7 bankruptcy takes about 3 to 4 months to administer. It's not really going to hold up your divorce that much. And I'll get to that in a minute as far as how the bankruptcy affects the progress of the divorce, but it is not significant, and that's not really a reason to wait to file a bankruptcy. Also, if there is marital debt involved and you wait till afterwards and there's an allocation, say a property settlement agreement or filing a divorce decree is issued, in which, say, the husband becomes responsible for all marital debt, well, you might be able to discharge your personal responsibility to that credit card company. But in a Chapter 7 bankruptcy, you cannot discharge an obligation under a property settlement agreement. You have to file a Chapter 13, which is more expensive and carries on. So, again, it's simpler to deal with marital debt in a Chapter 7 before the bankruptcy, before the divorce is final, before marital debt is addressed in a divorce in such a way as you may not be able to get rid of that obligation, at least to your spouse. Now, there are a couple instances in which it might be more advantageous to file after the divorce is final. And this is obviously where there are no issues as to a property settlement agreement or obligation on marital debt. The two instances are, first of all, there's something called means testing, and that has to do with household income in the 6 months leading up to the filing of the bankruptcy. If you are married, your joint income must be used. You're living together. You have household income, and that may put you in a situation where your income's problematic and may prevent you from filing a Chapter 7. But after the divorce is over, you're divorced, one spouse moves out, and therefore means testing would look at only your income, or certainly not include the ex-spouse's income. You're no longer married, you've moved out of the household. So it can make means testing issues simpler. Now, if you may get that advantage if you move out of the house before the divorce is final. So there may be a way of excluding the spouse's income under those circumstances. Again, on a case-by-case basis, but sometimes it can be simpler. If you're planning on living together until the divorce and then separating and selling the house, deeding it over to one party or the other, it might make more sense from a means testing standpoint, to file after the divorce is final. This is, of course, assuming that there are no issues as to home equity. So you don't want a situation where the husband and wife get divorced. Let's say the wife gets the house. The husband files a bankruptcy. Now the ex-husband files a bankruptcy after the divorce is final, but the home may still be in both names. There may be an issue of value of that home, where it might not be fully exempted. So you want to be able to preserve that home. Also, there's an advantage with regard to equitable distribution. Things are in a state of flux before the final divorce decree, where you don't know exactly how the marital assets are going to be distributed. So let's say only the husband files, and his share of that of the value of the home is not enough to exceed exemptions, and so he says, okay, my one half is enough, the other half is my spouse, and therefore there isn't enough to pay creditors if the home were to be sold. But what if the property settlement agreement subsequently says that the husband gets the house? And that can happen within 6 months. If it does happen within 6 months of the filing of the bankruptcy, then that incoming value, the non-filing spouse, her interest in the property it goes over to him. So he no longer is just has half the value, he has all the value, and he individually may not be able to exempt all of it. And that interest in the property that arises from the property settlement agreement is an asset of the estate and can cause a problem, and you might ultimately lose the home for that reason. So you might want to wait till all the shoes drop and you know what you're looking at. Who's responsible for what? Who has the house? And just to make sure there aren't any issues that are sort of hanging out there that can cause a problem for your bankruptcy, were you to file it before the divorce is final. Next question is, well, you're getting divorced. You have a divorce attorney. Can you include your attorney's fees in that bankruptcy? Well, I got marital debt, you got credit card debt, medical bills, personal loans, whatever it is. And I've also got this big bill from my attorney for the divorce. Can I include that in my bankruptcy? Well, the short answer is yes. Any debt owed by you at the time you file bankruptcy, in fact, must be listed in the bankruptcy. Whether it ultimately is discharged or not is another matter, but obviously the question is, when that's asked, can I include it in the bankruptcy, you're really saying, can I discharge it? Just some things to be aware of. Don't go making your overall strategy of the divorce and the use of the bankruptcy a way to get out of paying your attorney. Don't start out saying, well, I'm going to get divorced, I'm going to hire an attorney, I'm going to run up a bill, but I'm going to file bankruptcy, and so I'll get the divorce and not have to pay for it, at least from my end, for my attorney's fees. That can be seen as fraud by the bankruptcy court. You set out to do it this way. You knew at the time that you incurred the debt that you were ultimately going to bankrupt it, and that in your divorce attorney could say, hey, wait a minute, and object to the discharge of the debt as being incurred through fraud. You knew you were going to file bankruptcy. You knew you were going to do this all along. You had me working for you, and now you're trying to stiff me with the bankruptcy discharge. So that can cause a problem for you. So now also, what if your divorce isn't finished yet? Okay, you don't want to do that and discharge the attorney's fees and run into a situation where your attorney says, well, if you're not going to pay me all that you owed, you may not want to continue representing you, may seek to get out of the case, and now you don't have an attorney. And that can be a problem. So you really have to, again, each case is different. Talk to a bankruptcy attorney, see how you deal with the debt to your attorney in the best way possible. Sometimes it's necessary. Maybe there's a small remaining balance. For example, if you filed after the divorce is over, you have a big bill, you have paid a good portion of it, it's just towards the end you just ran out of money, you didn't have it anymore, and you have to list it. So there can be good faith reasons to list it, but you really have to be careful. And also, if you may be able to discharge your attorney's fees, but what about your spouse's? You may be ordered to pay your spouse's attorney's fees as part of spousal support. Your spouse's attorney fees could be considered a domestic support obligation and therefore become non-dischargeable. So those types of debts you have to be careful about that you may not be able to get out of in bankruptcy either. Now, we were talking about earlier about Chapter 7 and whether it would hold up your divorce. I don't, in most cases, no, I don't see where it would. As I said, Chapter 7 takes 3 or 4 months to administer and really dealing mainly with marital debt. And a lot of issues in your divorce can continue on. You can work on a lot of other issues while you're working through your bankruptcy. So you're not losing any ground, you're dealing with some other issues. You really can't deal with property settlement agreements or things like that in a division of property because if you have one spouse filing and the other one is not, which is where the delay may come in. But even then, while you're dealing with the debt, You can deal with other issues. The automatic stay that comes down that protects you in a bankruptcy can protect you from a lot of things, and creditors to a great extent. And the Bankruptcy Code provides for a lot of instances where it is a shield, but it isn't always a shield. There are things that the automatic stay does not stay. In the context of a divorce, this includes an action to establish paternity, an action to establish or modify a domestic support obligation like alimony or child support, so that can continue. Determining child custody and visitation, that can be dealt with while your bankruptcy is being processed through. Actions for domestic violence, those can be taken care of. And really, overall, the dissolution of the marriage, it's just that there cannot be, you have to wait until things play through with regard to assets on equitable distribution. That it really, like I said, you can if you do it early enough on as part of your overall strategy, all right, we're going to get rid of marital debt, whoever files, one or both of you. And while that's being taken care of, let's talk about who's going to get the kids, how we're going to work visitation, what kind of child support or alimony is going to be payable, things like that. So a lot of things can be taken care of while the bankruptcy is in process. So it usually doesn't hold things up if it's Chapter 7. Now, sometimes, I've been talking about Chapter 7 to a great extent, a bankruptcy can help you post-divorce. And I'm talking mainly about a Chapter 13. Divorce can cause a lot of financial stress in and of itself, financial problems you have to deal with. If you get behind on payments of alimony or child support, if you are having trouble dealing with some economic obligations under a property settlement agreement, for example, you're responsible for the payment of marital debt and you need to restructure that. Now, obligations under a property settlement agreement, to the extent they do not constitute a domestic support obligation, can be discharged to the extent not paid in Chapter 13. So Chapter 13 can help you deal with that obligation under a property settlement agreement. And it can also, for example, if you're responsible for paying the mortgage on the marital home, and you get behind on that, and you need to preserve that asset as a part of obligations you have under the divorce, then you can use the Chapter 13 to get current on those that mortgage obligation. So that can help. Now, just be aware that once you file that Chapter 13, you have to stay current. You can't get behind again on a domestic support obligation or other things while you're in the bankruptcy. The only way you're going to get a discharge at the end of the road, at the end of that Chapter 13 plan, is if during the plan, while you're in the Chapter 13, you stay current on your domestic support obligations, and you have to file paperwork and prove that prior to the issuance of discharge in your Chapter 13. So that's it for this month's Hangout. There are a lot of issues that come up in bankruptcy in the context of a divorce, but these are usually the biggest ones, the biggest questions that are asked, biggest issues. So I wanted to talk about them this month. Next month, we're going to look at it at bankruptcy and divorce from the other perspective. Today's show was about how it can help you as a debtor filing bankruptcy. Next month, for the November Hangout, I'm going to talk about how it affects the non-debtor spouse, the non-filing spouse, what his or her rights are, what can be done, what you have to do, what you're facing from that perspective. So next month, we ordinarily have these legal hangouts on the fourth Thursday. Fourth Thursday in November is Thanksgiving Day. So we're going to have it the month before, the week before, November 17th instead of November 24th at 5 p.m. And it's going to be on what a non-debtor spouse or ex-spouse can do when the other spouse or ex-spouse files bankruptcy, and how you can protect yourself. Also, be aware, a lot of these answers and a lot of the information I've been providing on this Hangout next month is available in one of my books. This is over here. Top questions divorcing couples ask about New Jersey bankruptcy. It's available for free download on my website. So if you want answers to these questions, can't wait for next month, or you want something where it's written down as opposed to in a video, just download the book for free, take a look at it, get that information. If you like this video, please push that thumbs up button at the bottom of the video, and even better, if you like what you see on my channel, please be sure to subscribe. So that's it for this month. I'll see you as we approach the holidays, as we approach Thanksgiving, and we'll talk more about bankruptcy issues and divorce. Until then, have a good evening.